Intellectual property is just a piece of property, and it ought to be the same. And that's why this international question is so significant in intellectual property law in a way that's different from other areas of the law. When a business has a copyright, the business people expect that the copyright works the same way all over. So there is a really good reason why, in the sphere of intellectual property, it is important that the judges all analyse and we look at what all are doing, because really at the end of the day, the copyright in one country should have the same characteristics, it should work in the same way, and that's why it's necessary, I would say, and certainly important, that we all look at each other and work out what we're doing. WIPO has a really interesting role to play in bringing judges together in intellectual property. My own view of intellectual property is it's a completely international area, and what we need is judges to talk to each other. And the thing which strikes me most of all is that we all have the same problems and we can learn from each other. I find it very, very beneficial, and it's a really important initiative, and I'm really pleased to support it. The thing with WIPO, because it is so international, I'm used to European level meetings. That's quite common. The European judges get together quite a lot in intellectual property. I go to the United States. I've been to China, but I haven't really met judges from outside those major industrial countries. WIPO brings all countries together instead of just the industrialized world who are all talking to each other already at the judicial level. It would be fantastic for WIPO to use its expertise to curate the mass of judgments which are in all the countries in the world. That would allow them to help the judges in every country to identify which judgments actually are the ones that need to be looked at.